My name's Carter Burwell. I'm here on behalf of Matthew Hyman, who's the chair of our International and National Security Law Practice Group at the Federalist Society. And my job here is very limited. I'm here to just introduce Judge Bress, who is the moderator. Judge Bress is a judge on the Ninth Circuit Court of Appeals. He sits in San Francisco, which is, I think, just about an hour and a half north of where he grew up in Gilroy, California, which everyone knows is the garlic capital of the world. Judge Bress went to Harvard for college and then had the good sense to go down to the University of Virginia for law school, where he graduated, I think, 3 decades before I did. He then went and stayed in Charlottesville, clerked for Judge Wilkinson and Justice Scalia. He's been on the bench since 2019. Before that time, he served time in a couple law firms and also was a professor at the University of Virginia School of Law and also Catholic. So thank you very much for moderating today for us, sir.
Thank you. Well, it's a Washington tradition for somebody to introduce the introducer. So I wanted to say thank you, Carter, and great to be here at the Federalist Society. This has just been another wonderful set of days of talks. I want to particularly thank the staff of the Federalist Society that helped us organize this panel and that's done just a fantastic job organizing the wedding of all time here in Washington, D.C. So, okay, with that, the afternoon session we have today is called Made in China, the Legal Battle Over America's Supply Chains. And, you know, I think we all have issues that we have a sense are extremely important, but that pose real risks and threats for the United States, but that we also feel we don't fully understand as well. So as we constantly use Chinese goods and we constantly use materials that are sourced from China, we might sometimes ask ourselves, what are the risks that this poses to us as a country? What are some of the issues that we face as a result of this? And what are some of the legal issues that we may encounter along the way on this? And so to help us answer this, we have 4 incredible experts that have been hand-selected by the gurus of the Federalist Society, and I'm going to introduce them. We have, sitting 2 over, Rein, who is a fellow at the American Enterprise Institute, where he writes on the intersection of U.S.-China relations, technology, and national power. He's also an adjunct assistant professor in the Securities Studies program at Georgetown University. From 2022 to 24, Ryan was an advisor for U.S.-China bilateral affairs at the U.S. Department of State, where he helped launch the Office of China Coordination and served as the U.S. government's main point of contact with the Chinese embassy. So Ryan, welcome. Over to Ryan's left, we have the Honorable Nazak Nikakhtar. She is an international trade and national security attorney and a partner at Wiley Rein here in Washington, D.C. She's chair of Wiley's national security practice. Nazak is a leading expert in international trade and global transactions, domestic and international competition, customs compliance, export controls, supply chain assessments, and probably many more things than I've just listed there. From 2018 to 2021, she served as the Department of Commerce Assistant Secretary for Industry and Analysis at the International Trade Administration. And in this and many other roles in our government, she has been a leader in shaping America's international trade and related national security practices and policies. So Nazak, welcome. Sitting right to my left is Dr. Marta Wosinska, who is a senior fellow at the Center on Health Policy. She is a healthcare economist with a PhD in economics, I learned from Berkeley, which is a good Northern California connection. She has a particular expertise in prescription drugs and pharmaceutical supply chains. She has extensive experience in government, including as the director of the Bureau of Economics of the Federal Trade Commission and chief healthcare economist in the Office of the Inspector General at HHS. On the academic side, she was consulting professor and deputy director for policy at a Center for Health Policy at Duke University, and also an assistant professor at the Harvard Business School. Lastly, on the far left, I've always associated you, John, with the far left. John's great.
I've been put there for my sins, believe me.
John's greatest claim to fame is that he's my Bay Area lunch buddy. But aside from that, he's also a distinguished professor of law at the University of California, Berkeley. He's a non-resident senior fellow at AEI. He's also a distinguished visiting professor at the University of Texas at Austin's New School of Civic Leadership. John is the author of numerous books and articles on executive power, international law, and constitutional law. He's served in various roles in government, including at the Department of Justice and as a law clerk to Justice Clarence Thomas. So please join me in a round of applause for our panelists. Okay, so the way this will work, each panelist is going to give some opening remarks, especially reflecting on some of their areas of expertise. We'll then kind of have an open discussion that I will attempt to lead, and then we'll have time for questions. And so we will begin with Marta.
Thank you very much. It's really great to be here. What we thought might be helpful as we get into this discussion about what we're going to do about China and to what extent we have the tools, we thought we would give you a sense of why we have so much exposure to China, why we rely on China so heavily. And you have heard about rare minerals, right? There was clearly something that now everyone is aware of. And this extends to a lot of other industries. The area that I am most familiar with is pharmaceuticals. And even though I think generally it's mischaracterized how much we rely for active pharmaceutical ingredients when it comes to China, but when you look at the upstream and the chemicals, the key starting materials, the reagents, the solvents that you need for chemical reactions, that's very heavily dependent on China. So we have this incredible exposure. And what I wanted to do is to step back from a specific sector and briefly talk as an economist about how the US market-driven system really differs from the Chinese system. So, and what is the role of government in that space? Because I think that really explains, when you put those two together, why we end up having a problem. So, China 40 years ago was an agrarian society, and why have they risen as an economic power so quickly? Some of it, and Rein and Nazak are going to talk about things that they have done that really are not above board. That things that are much more nefarious. But a lot of what they have done is actually very much above board that a lot of other governments do, including the US government. So let me first talk just very briefly about sort of what are the pros and cons of the market-driven economy like we have in the US. And the role that the government plays in this. So, clearly efficient allocation of resources. Markets can send very effectively signals through supply and demand as prices adjust, and just a very efficient system. And we all fully understand that. Where there are cons is that there are situations where the parties that are part of the decision are not fully internalizing the implications of what their behavior might have on others, either in the short term, in the short term or in the long term. And there are certain areas where just markets are not nearly as efficient and either overinvest or underinvest. We have overproduction, underproduction from a societal standpoint. We would not really have a defense without the role of government. That's a public good that belongs there. Basic science, we would have a hard time with generating basic science without government's involvement, because you can't really appropriate some very basic ideas if it's not patentable yet, like you can't sort of, and so there wouldn't be an incentive to do this. The same when it comes to a lot of infrastructure. So there's sort of areas where the government can lean in and change sort of how markets operate. So this is sort of where government leans in. On the industrial policy, the US government has not been leaning in historically all that much. And where it has been leaning in is often political, not economic. So if you think about some of the subsidies that we have in industrial policy in agriculture, sugar, ethanol, right? Those are, I would argue, very politically driven and not because it leads to economic growth for the United States. I mean, there's always the economic argument attached to them, but it is really an important constituency, and the support comes from that. Flip it to China. So China is what I would describe more of a hybrid economy. It's not like, Soviet Union centrally planned where they would assign market shares to firms. They would say, you make this much, you make that much. It's a hybrid because they actually do allow the markets to operate reasonably free in certain areas, and they have a lot of control in others. So some of the consumer products in the domestic markets, they'll just let them do what they want to do, and maybe on the services. But if it's a strategic area and it involves export, so they very much think about what is going to create growth for the Chinese economy. What is going to position them well, not this year or next year, but in the long run? How are we going to sustain this growth? And then they lean in, for example, the banking system is controlled by the government, and they will create subsidies and they will build infrastructure. They have leaned in very heavily in making sure that they build the kind of workforce that they need to sustain being really innovative. So they have done a lot of things, not directly by saying you make this, you make that, but rather sort of subsidizing and sort of creating the infrastructure for a certain industry to be lifted. And of course, they can step in and say, do something different. And clearly a lot of inefficiency. They can overbuild very easily, and that's clearly creates incentives for dumping. But they do have this sort of longer-term orientation. It gives them the ability to have that, and then also the ability to mobilize resources where the markets wouldn't necessarily do that. So you bring these two together. So why did we end up relying so much on China? If you bring these two, and just I was going to say, a lot of what China does, again, I'll mention. Some of it is above board, and Rein and Nazak are going to talk about where they sort of go not so much. We have a lot of foreign direct investment in the US. China very much welcomes it too, and it always comes with jobs, right? That's a positive. And also, there's some technology transfer with foreign direct investment always. It's just that the Chinese take it to a whole different level. But some of the tools that they use are exactly the same tools that the US might use or any other country. So when you bring these two systems together, we start having quite a bit of a problem, even if they were to do things above board, I would argue. And it's because if you think about it, all the companies that have wanted to go to China and do business in China, they think about their own profits. They're thinking about their quarterly profits next year. They're not thinking about 5 years from now. And what implications might this mean that if our IP goes to them and they use IP from all the other firms, right? What does this mean for China? This is not something that firms on their own internalize as they lean in. And so you marry this sort of drive for efficiency, for lower prices, this sort of very short-term perspective, and then you come across a government that very much sort of tries to position itself strategically. And you can see how we sort of are doing this to ourselves to rely on China because we're letting the market and the kind of the short-termism that comes with our markets sort of drive us there. So I'll pause here and then you can go and talk about how they sort of very much encourage this, right? So.
Great. Brian?
Thanks so much. Thanks very much, Judge Bress. Thanks to the Federalist Society for hosting us today. As a non-lawyer here at the National Lawyers Convention, it feels very much like I'm in the worst remake ever of Suits, but I still hope that I can say some things that might be interesting and novel to you all. And I hope you don't mind, but I've prepared some remarks for you group of lawyers on something that I've spent the past 10 years really living at the heart of, and that is our export control policy and the modulation of commerce between the United States and China. So I would just start by saying, the legal architecture that we are using to compete with China was originally built to regulate Soviet wheat sales. It was certainly not meant to modulate commerce and to control the flow of technology to the world's second largest economy, a hostile foreign power in peacetime. Now, I am a fan of small government and a deep believer in the limits of state power as articulated in our Constitution, but I'm also an American citizen who recognizes that our current legal framework is structurally incapable of denying resources as I think that we need to do for our national security. So for the past 10 years, I have watched our government attempt to prevent the technology transfer from American firms to the Chinese military using authorities that were really designed for Colombian drug cartels and Iranian banks. And the result has been pretty predictable. I think the result has been strategically untenable. And I would point out to you all three failures as I see them. The first is that our blacklist system is structurally inadequate. Since 2018, the Department of Commerce has added nearly 1,000 Chinese and Hong Kong-based entities to its entity list. And at first glance, that might sound very impressive, but when you realize that there are more than 25,000 Chinese companies licensed to sell weapons and equipment to the People's Liberation Army, and that they spawn subsidiaries faster than our interagency can designate them, it becomes a pretty disastrous failure, in my view. In fact, designating a single entity can take months or in some cases even years, and it doesn't always stick. I've certainly been frustrated in my efforts to add a number of companies to our entity list. The Xiaomi versus Department of Defense case in 2021, I think, is a very clear example of the problem. Here is a company that has received awards from the Chinese military, but was able to successfully challenge its designation because the Department of Defense could not prove specific military ties to the satisfaction of a federal judge. The result of this repeated bashing of our head against a wall has been pretty frustrating as I see it. We're playing whack-a-mole with due process hammers where China runs a unified strategy designed to exploit our procedural constraints. The second failure I would stipulate is that we already possess powerful authorities that are sitting unused. I speak, of course, of Executive Order 13873, the ICTS rule, which grants sweeping power to the president to prohibit entire classes of transactions with specific foreign entities. At least on the books, as it has been interpreted by the courts so far, the Department of Commerce tomorrow could restrict all transactions with very specific Chinese enterprises. It's a tremendously powerful tool, and yet it has only been invoked twice since 2019, which is why 5 chairmen of different congressional committees sent a letter to the Department of Commerce Secretary Howard Lutnick earlier this week, asking, in my view, rightly, why? Some of you, I think, will hear this as a call for greater or unchecked executive power, but it isn't. This is calling for authorities designed for the actual threat that we are facing with appropriate oversight. But I am here to tell you, at least in my experience, which I'm happy to speak more to, that the scale of this challenge is simply too vast to require proving individual malicious intent for every subsidiary of every Chinese military enterprise. The third challenge is that we are fighting an asymmetric legal war with both of our hands tied. And here is maybe where I would put a little bit of distance from Marta's initial laydown, but I'm happy to talk more about it, how I see it. You know, I was in Shanghai a month ago today when China unveiled a sweeping new licensing regime for rare earth minerals, which has been the subject of presidential negotiation. But the move followed a familiar pattern, even if we've seen it paused for the next year. While our system of trade controls is built on auditable blacklists underpinned by the rule of law, theirs is built on opaque whitelists with exemptions carved out on the basis of state coercion. And this, I think, is the fundamental problem that justifies re-examining some of our existing legal authorities, or at least asking questions. When US companies need rare earths or battery-grade lithium, they have to come crawling to the Ministry of Commerce in China for a license. The Chinese government demands that they hand over proprietary information, including vendor lists, chemical formulas, full forensics on their supply chains. It offers no assurance that this data won't reach the hands of China's intelligence services or their competitors in China, and at least based on the US executives that I talked to, they believe that it is in fact reaching those people. And this is a serious problem for U.S. competitiveness. Meanwhile, we maintain dozens of different restricted entity lists, each with different statutory authorities, evidentiary standards, and challenge procedures, each restricting access to different resources, whether it's U.S. Department of Defense or federal funding or procurement, whether it's operating licenses to work in the United States, as we've just heard from Chairman Carr, whether it's U.S. origin equipment, is the entity list is designed to prevent the transfer of. A Chinese firm can be on 3 lists, but exempt from another 4. And this, I think, is untenable. These unintended loopholes in the letter of the law are, in my view, relics of our national legal debt, one that has grown as a byproduct of the administrative state and accumulated as we have struggled to accept the nature of the competition that we are in. Serious legal reform, I think, demands that we consider creating new legal authorities in institutions that are fit for purpose. And I would suggest 3 things to you all. I'm curious to hear what you have to say and what my co-panelists have to say. The first is that I think we ought to start with expedited designations. If an entity is controlled by the Chinese government or military, that designation by the US government should take days, not months. And I know that some of you are thinking that rapid designation sounds like stripping due process, but I am not talking about eliminating review. I'm talking about shifting the evidentiary burden to designate faster based on ownership structure, and then allow expedited review afterward if there are, in fact, challenges and problems that are tenable. We don't require proof of individual malfeasance before restricting transactions with Iran's Revolutionary Guard Corps, and I don't understand why we should require it for subsidiaries of China's military contractors. The second suggestion I would make is to consolidate the existing executive power of the United States, to consolidate our blacklists. We need one restricted entity database, one standard of review, and one adjudication process. And yes, this would require Congress to create a unified authority. But I challenge you to try explaining to your clients why their Chinese counterparty can legally receive US investment despite being on the entity list, as has happened with thousands of universities in China who have benefited from Department of Defense research funding, as Congress found last month. And I would also challenge you to have them explain why, if they are listed as a Chinese military company under Section 1260H of the National Defense Authorization Act, they can still access American capital markets. The current fragmentation of our system forces law-abiding American companies to navigate a compliance minefield while their Chinese competitors exploit every seam. The final recommendation I would have for you all, and the final thing I think we should give real credence to, is implementing real reciprocity with China. When China maintains opaque whitelists for critical minerals, we should match their approach. Require Chinese firms to petition for access to our markets. And look, I understand the discomfort I think many of you will have with that claim. Many of you have spent your careers ensuring that the government can't arbitrarily restrict commercial freedom, and that is noble work. It's part of what makes our system worth defending in the first place. But I am worried that some of our procedural legal safeguards designed to prevent arbitrary government action and uphold the rule of law are creating arbitrage opportunities for our adversaries to undermine it. At the end of the day, the question is not whether to abandon due process in the legal review of our export controls, but how to adapt it for competition with an adversary that weaponizes our legal principles against us. The theme of this conference is new legal frontiers, but in my view, the frontier we face is an ancient one. It's how a liberal democracy can defend itself against authoritarian mercantilism without becoming what it fights. The question is whether we will adapt our legal architecture to match the competition we're actually in, or whether we're going to let procedural paralysis make that choice for us. Thank you for your time, and I hope that I've said something that might be provocative or interesting to you.
Great, thank you, Ryan. And we'll hear next from Nazak.
Yeah, thank you, and wonderful to be with you all today. I've had the privilege or maybe misfortune of being on the front lines of the U.S.-China economic battle since China's entry into the WTO, where I served as a civil servant at the Commerce Department and set up the China Non-Market Economy Office then. As soon as China joined the WTO, it started dumping goods in the United States. We saw the volume of imports from China increasing and increasing and increasing. We lost industry one after another. We were screaming into the wind, but nobody was listening because it was just the commodity stuff. But when I look at industry, also as an economist, not just a lawyer, it's really, I describe it as like a triangle. The bottom rung is the commodity, and the revenue from the commodity side funds the next gen technology, and then the revenue from that funds the next gen, so on and so forth. So we lost the commodity sector, nobody said anything, but with that we lost the revenue stream. Our companies went one rung up the ladder. When China controlled that bottom level commodity sector, it came up. And companies found themselves finally squeezed into that very top point of that triangle until they lost their industry and there was nothing left to keep. During that time, the U.S. government assured the world that China was going to reform. In 2004 to 2006, China made submissions to us. There are bubbles of capitalism here. We looked through the thousands and thousands of pages that China submitted, and there was no real bubble of anything, so we dismissed those. We continue to treat China as a non-market economy where the government controls prices and the predatory pricing of predatory pricing and counter those with our dumping laws. Then the financial crisis hit, and I think China looked to the U.S. economy and said, "Wow!" And there might have been some reform efforts there, but China looks and sees that the way that we govern doesn't give the government control, and the financial crisis proved that. And I think that really scared them. And by this time, I'm in the private sector, and all of a sudden, we see the pendulum swing the other way. China doubles down on its non-market system. It creates layers between the central government and the local governments to better control the local government from the very, very top. This became very alarming. At the same time, between 2008 to 2015, the government says, China is not reforming the way we thought we was. This pendulum is starting to swing the other way. Oh, we know what we're going to do. We're just going to give China more. So remember, we lost our industries. Then we do this export control reform business where we loosen our rules, we loosen our regulations, and we give more to China. The Commerce Department, instead of becoming a regulatory and sort of economic promotion agency, became an export promotion agency. The International Trade Administration started promoting the exports of U.S. goods to China. And the export control regime weakened, so we could export more technology to China. Of course, with the exports of goods, you create this sort of economic vulnerability, right? I think by 2015, the U.S. government said, this isn't working out so good. We're not having the intended effect. And I think that's what enabled President Trump, among other factors, to win. I think people really started seeing where this was going. We've lost our chip sector. I'm just going to give you an example. We've lost our chip sector with chips that funnels hypersonics, right? China's growth in hypersonics. We've lost critical minerals. We've lost robotics. We've lost chemical manufacturing, pharmaceuticals, industrial machinery, drones, biotechnology, autos, aerospace, where China has grown at our expense, as the rest of the world's expense. But we're struggling to onshore. But the reason we can't onshore is because, as you've heard, our laws are weak. And I'll give you a few examples. Forced labor. With how rampant forced labor is in China and our laws that prohibit the importation of forced labor, we're barely going after anything. The Information Communication Technology Services, ICTS, executive order of President Trump during his first term. I mean, we're barely restricting Chinese software into anything here. Think about the threats, the vulnerabilities to the energy grid. If I put an EV charging station that actually can transfer software into the energy grid. That's just one example of how vulnerable the grid is. Our anti-dumping laws basically say that if any country produces something cheaper than the United States, we don't deserve to have an industry. That's how these laws work. Our countervailing duty laws or subsidy laws, well, China doesn't notify its subsidies to the WTO, so how are we going to know what to go after? I mean, our export control laws are founded on, and I agree with everything Ryan said, but we've adopted this premise that we're running faster and that we're clairvoyant somehow. We can predict where the choke point technology is. The truth of the matter is, we're not necessarily running faster. We were just so farther ahead for decades that we created regulatory barriers to slow us down, and now China's neck and neck, right? So China's been running fast. China indigenized the semiconductor industry in less than 15 years, what we took decades to build. And let's be frank, we're not clairvoyant. Every choke point, like I'm going to let China have everything except this one little choke point, and then somehow China overcomes that obstacle, right? We saw that with DeepSeek. We've seen that in advanced chips. Our court systems, our court systems are broken. The judges are biased. The WTO, I used to teach WTO at Georgetown. I went to the WTO. The WTO said, that the head of trade said, we can't choose between the United States and China because you're our two largest partner. And if we choose, the WTO will seek to exist. The WTO is more interested in self-preservation than doing what the member states entrusted the WTO to do. With China, I'll end with saying this. I don't think you can trade with China and keep your industries. I think the U.S. policy should be to gradually shift away, kind of like how we put in standards, environmental or whatever. By X year, you have to get to this goal. By whatever year, you have to get to this goal. I think we really need a policy that gradually moves away from China. And I'll finally say this. China has the second largest GDP in the world and one of the lowest per capita GNI. What does that tell you? Even if you buy what does it matter if I buy shoes from China or Tupperware from China or whatever? Every time you transfer money to China, $1, the money doesn't go to the people. The money doesn't go to the companies. It goes straight into the CCP's pocket that they use to fund their genocide or build out the PLA to our detriment. Thank you.
Thank you. And John.
Thanks, everybody, for having me. And it's great to be on a panel chaired by Judge Bress, who is from Gilroy, which is the garlic capital of the world. Dan, when we go to lunch, does not smell like he's from the garlic capital of the world, I assure you. But I'm a big fan of McDonald's. And I don't know if you know this, Dan, that the McDonald's in Northern California has a celebratory dish when it's harvest season called Gilroy garlic fries, right? Which I've never seen anywhere else in the country but Northern California. So every time I have a French fry, I think of Dan Bress. Just true. So it's really great to be here. And so I thought my perspective and contribution would be about the legal framework to apply in light of the disturbing facts you've all heard, and to explain how this interrelates, I think, with the oral arguments this week in the VOS Industries versus Trump case involving the worldwide tariff regime and whether it's legal under IEEPA. And because IEEPA would be one of the primary tools to use to heighten the kind of restrictions we would want, that you've heard described by the factual experts about that we would want in this contest with China, I worry that the arguments that the administration has made in the tariff case that might get rejected could have as a secondary consequence making it harder to create a tougher trade regime against China to protect the kind of supply chains that we need to continue this contest with them. I'd be happy to have an argument about this, but I think you listen to the panel, you read the literature, and it's, I think, without doubt that China is the primary threat to the national security of the United States in the long term. We have maybe some greater short-term threats, which the administration, I think, is addressing with Russia's invasion of Ukraine and the Middle East with the attack by Hamas from Gaza into Israel. But the long-term threat, I think, comes from China. And the reason I say that is that the threat is a combination of capability and intentions. There's no doubt from all the facts you've heard that the capabilities of China are approaching ours and might exceed ours by 2030. The size of the economy in China is about $18 trillion. Our economy is about $30 trillion, but the slope of the curve is such that economists estimate that China's economy might tie or exceed ours in the 2030s. China is embarked on a huge military expansion program. So just take the Navy, which would be the most important, I think, armed service if we were to engage in any kind of conflict with China. China already has the largest Navy in the world, and it's projected by the 2030s perhaps to double the size of our Navy because China has, I was looking at a study earlier today that said some estimates are that China has 200 times the shipbuilding capacity of the United States. So you can see China is also competing heavily in things like hypersonic missiles, where they actually may already exceed our capabilities, would also be an important weapon in any kind of war. They're already constantly testing our cyber defenses and intruding into American computer networks. They are developing space-based weapons to attack the satellite networks we use as the backbone of our modern fighting systems. It's also a question of what the Chinese leadership says is their goal. And they are openly declaring that they want to replace the United States as the leading power of the world, in the world. They repeatedly talk about invading and retaking Taiwan. And they have put up artificial islands to take control of the key waterways in the South China Seas. So we could have an argument about that. It seems to me China is the great long-term threat against our national security. What can we do about it? I think legally, the tools are there, statutorily. I think what you've heard a description of is that in terms of implementation by our agencies, we're kind of scattered and not focused on China. And as some people said, a lot of the regimes are designed for problems we've had in the past with the Soviets or other countries. But take IEEPA, for example, which is on the minds of many with the oral arguments today. IEEPA, I think, provides extraordinary authority to the president to take all of the measures that people would say we would want to have. It says, that in the case of an unusual and extraordinary threat to the national security and economy of the United States, the president can, and we're just focusing in the case this week about importation and exportation, but it goes much farther. It also talks about voiding any foreign ownership of any property in the United States. Right, of blocking any transaction involving any foreigner or foreign property in the United States. It's not just regulate, it also says prohibit, that you don't just get to regulate these transactions, you could actually just prohibit entirely the kinds of transactions we might be worried about with China. The problem is some of the arguments that are being made in the court I think, quite in good faith, though, might rebound badly on an effort to use these laws against China. First of all, it seems to me IEEPA was designed actually for more of the situation with China than with a trade deficit. The traditional use of IEEPA has been to name specific countries and the threats they pose, and then to outline a series of economic trade sanctions and restrictions on them. So the typical one would be trade restrictions on Cuba, North Korea, Iran, Russia now after the Ukraine war, and so on. The problem with the Trump administration's claim that the trade deficit is a national security threat is that the trade deficit is not really unusual or extraordinary. It's been around since the Nixon years. It's the same size as it was during the Bush administration. It's rough. It really it fluctuates, but hasn't really been unchanged. So on this score, I think if the current administration was to define China as a national security threat, I actually think that would be a better argument and narrower than the one it's making at the court. The one that's making it at the court, though, that could result in problems is the second question in the tariff case, which is, Given those broad words in the statute, does that include the power to impose a tariff? Personally, it seems to me that it does, because it seems to me that if you can block entirely, if you can put an embargo on trade with a country, all traffic with a country, then why couldn't you just allow traffic with that country and impose a financial penalty on it, right? It seems to me like the lesser power includes the greater power. And you saw Justice Kavanaugh made that argument or asked questions along those lines at the oral arguments. I'm glad he took time out from watching Sports Center to come up with some of these tough questions for the counsel. I also can imagine him yelling and screaming at the TV screen when he sees a bad ref call in a way that he doesn't at the court during oral argument. Having played intramural basketball with him at Yale Law School, which is not a pretty sight that anyone should ever have to watch. So, but suppose the court rejects that argument. If you listen to the oral arguments, you heard Chief Justice Roberts try to make this proposal that the major questions doctrine could be employed. And if you employ the major questions doctrine to IEPA, the idea that, if the statute is not clear, it doesn't give some kind of authority it doesn't give some kind of authority that's not in the clear text of the statute, and that Congress would have to repass or add a new law, that could undermine the ability of the Trump administration or any future president to impose very comprehensive, broad-scaled economic sanctions on China. Right? Some of the things that we've talked about, heard about, involve not just sanctions, exports and imports, but trying to rebuild domestic industry, right? Trying to create U.S. critical Earth's resources to try to retake the lead in chips, right? It's not to stop the import necessarily alone of these Chinese products, but to build a domestic sector, or to rebuild, because we used to have them, but to rebuild domestic sector. And suppose the president tries to do that in IEPA. IEPA doesn't specifically talk about a subsidies regime. It doesn't specifically talk about aiding U.S. industry. There are other laws that we could talk about later, like the Defense Production Act, that might be used and was used during the COVID emergency to try to rapidly build up industry. But a court that took the attitude that national security laws have to be specific in the powers they give to the president in order to build a kind of regime to fight China, I don't know then if we do have enough legal authorities. I also think this would be quite out of tradition with American foreign relations law, and I think actually gets the non-delegation doctrine wrong. The major questions doctrine is a prophylactic rule to prevent excessive delegation from Congress to the president. Right? It's a statutory canon of construction, but it's there for the constitutional reason of the non-delegation doctrine. The court has said in Curtis Wright, this is the part of Curtis Wright that actually was, part of the decision, was that the non-delegation doctrine does not apply to foreign affairs because the world is a dangerous place and it's unpredictable, and the president's institutional capabilities exceed those of a legislature in responding to threats where the stakes are so high and immediate, like national security. And so the court quite clearly said, we will not apply non-delegation principles to foreign affairs. If the court is going to, in this tariff case, turn around and start imposing the major question doctrine on foreign policy and national security laws, it is going to have to overturn or get rid of Curtis Wright, but also, I think, deny the just sort of undisputed institutional capabilities of the presidency and the executive branch and the way it works with the legislature, and put up a barrier, I think, between a president and a Congress who want to cooperate together to create the necessary legal regimes to take measures against Chinese efforts to take control of our supply chains or use their control of their monopoly in order, right, to leverage, for example, information and technology out of our companies, or to hold hostage sectors of the U.S. economy to their decisions. I think we can combat those all now under the laws as they've concurrently understood, but I worry about how far the Supreme Court will go if it overrules the Trump tariffs in undermining those very important laws, which I think are, in the long run, in my opinion, are far more important to our national security, defeating China, than putting tariffs, many of them on our allies in the world. In fact, some of the allies that we are going to need in this long-term rivalry we have with China. Thanks very much.
So I have a few follow-up questions, and then we'll open it up to the audience. First, I want to talk in a moment about how to address this and the different ways we might consider it. I first want to just probe the nature of the problem for a minute and ask the following. What you've all laid out causes some degree of concern. I think to anyone who's not familiar with this issue, just hearing it is on the range of deeply concerning to extremely frightening. On the other hand, people prefer to have easy availability of goods. They want cheaper goods. They don't want to work in jobs that they feel are sort of not jobs they want Americans to have. They want full labor and environmental laws here. They care less about those in other countries. And so it seems like we've reached this sort of dependency on China. And the question I would ask, you described a lot of risks, but clearly there must be a good reason why we have this current situation that we're in, and that people, through market forces or otherwise may want it. And how do you respond to that sort of reaction to what you've said? And Nazak, maybe you want to just take the lead, and then we'll hear from Marta.
Yeah, I mean, I think, look, 25 years ago, we weren't as dependent on China. And I remember 30 years ago, I was a law student, and I was on student loans, and I could still go to Kmart and furnish my apartment and stuff. So I don't think that there's this foregone conclusion that we need to just depend on China. I will say that every time people say that Chinese goods are cheap, it makes me cringe, because it's not cheap. It's predatorily priced. It's distortedly priced. And if you bring distortions into a market economy, it's going to distort your economy, and it's going to throw off the equilibrium. And so it is best, I think, everybody who really believes in a healthy economies, that you don't have those distortions in your economy. Your economy can be healthier. I actually think that Americans do want to work, and I think Americans do want to have jobs. And I represent industries in some of the poorest parts of the country, and those workers want to work. And if those workers don't have the job at that factory and that factory shuts down, they have no other jobs. And I think what China has prevented us from doing is, no, we don't want potentially the way that the Chinese manufacture, but because manufactured went over there, it's prevented us from innovating and thinking about how to manufacture in a way that works with our culture, that works with our business ethics, that doesn't harm our workers, and that innovates more. So I think how China has sort of undermined our economy and our ability to innovate in manufacturing and manufacture in a way that makes sense for American is a huge damage too that's really never discussed.
Marta, do you want to comment?
I think it's pretty much what I said in my remarks. Is the way we approach how our markets should function and what we value doesn't really necessarily account for some of the potential problems that can arise, right? We don't think about national security concerns. I mean, I do a lot of work on drug shortages. How many patients are worried that there might be a drug shortage? We don't even think about it. Doctors don't even think about the possibility that there might be a drug shortage. But it's how pharmacies in hospitals buy drugs is ultimately why we actually have shortages, because there is a race to the bottom. And there's just not enough investment, not enough attention paid to reliability of supply chains. It's of their own doing, but they don't tend to think about it. And so it makes it very challenging because, so again, how do you close this gap? This is a role for the government to step in and either get, the society on board and lean in one way or the other. But that's the reality of it, is that if we individually make these decisions, we end up in a place like this.
Let me ask a follow-up to Rein, which relates to other countries. So we've been talking a lot about China and the United States, but of course China has great alliances with Russia in particular. And how do we think about this as sort of a global problem, especially given China's relationship with states that we don't necessarily value as partners?
It's a good question. Thanks very much, Judge Bress. But yeah, I guess I'll speak a little bit to the experience dealing directly with Chinese diplomats across the table for a very long time. the great honor. And they claim not to have an alliance with Russia. They have a no limits partnership, however, and obviously there are open source indications that China has provided some kind of support, maybe even material support, definitely material support, but maybe even bordering on lethal support for Russia's war effort. And it is very difficult to sustain a trade relationship with China and to sustain energy partnerships, with Russia at the same time. I think our friends in Europe really see this issue most acutely. I think they view China's support for the Russian war effort to be one of the most destabilizing aspects of China's foreign policy. In fact, during a recent foreign minister visit to China by one of the Baltic states, I think the foreign minister said that it is the defining element of that country's particular bilateral relationship with China. And so this isn't any surprise. But the problem, again, as we've kind of run into, maybe I'll take this time to just briefly touch on two things. First of all, I'm not going to claim to know more about the law than Professor John Yoo. But
I wish more people would say that.
Well, yeah. You gotta let me finish.
Including most of my students.
I've never said that.
I'm certainly not going to claim to know more about the law than him. But I will say, it's. I think it's unfortunate. Let me just speak from the perspective of government, right? During the Biden administration, the government has enjoyed or did enjoy the existence of a new authority in ICTS, first created by President Trump in 2019. It did not deploy it very often. It deployed it exactly once against connected vehicles from China, which they were exporting to other countries in Europe, but also in the United States. So we basically restricted the export of Chinese electric vehicles to the United States using ICTS. The government was reticent, the Biden administration was reticent to make excessive use of ICTS, in my view, in my experience, because it did not want to invite testing the limits of that executive power. It is a tremendous authority, but when you start using it willy-nilly, you invite judicial review. You invite the opportunity to really test the limits of that particular authority. And so it was very interesting being in government, having this tool available, and then electing not to use it because it would define the limits of what appeared to be great power. But it was used when in connected vehicles. To Judge Bress's point, it was used for connected vehicles because this was a component, this was a particular commodity that could be sold everywhere and that our European friends were exceedingly worried about too, putting out of business European companies. And so I think it's interesting, again, I'm not a lawyer, but it's interesting to me to watch when the US government has an incentive to use certain legal tools because they align with the interests of our friends and allies, to Professor Yoo's point. When we do so to secure global supply chains, even though it is a unilateral power. And then perhaps that makes the case for encouraging some of our friends and allies to adopt similar authorities, to adopt similar export control regimes, or perhaps even similar ICTS rules so they can follow in our footsteps.
So a question for all the panelists, and maybe we'll start with John. As lawyers, we sometimes look at this and ask, well, let's put some law on this and let's resolve this problem with law. Then you run into problems that are so massive and you ask, is law only a part or even a small part of the solution to this? John, what's your sense of the role law can play in this? Because the president makes an action and it's immediately challenged in court and it's tied up in the legal system for many months. And some of these things seem like very fast-moving issues as well. So to what extent is this about laws, about markets, about norms, about diplomacy? What role does law play?
Thanks. It's a great question, Judge. And I think part of it from the sort of Federal Society, member perspective is usually we think of something external to law providing the goal, and then the law gives us the means to achieve it, and then we design it in a way that's consistent with the statutes that we have, and then we ask Congress or the agencies to provide more. And I think in this area, it goes back to your first question, which is, you're going to have a goal like national security, securing things in the economy for national security reasons, but there's going to be a trade-off. There's going to be a cost in terms of higher prices, a less efficient market, and then how do you achieve the right balance using the legal tools we have available? And so one thing I think to help us with that is that, we lawyers should look outside law to try to understand some of the strategy. Like, what is the best economic policy strategy for the United States to pursue? And you can see that's, one of the questions roiling Washington, D.C. and the Trump administration right now. My druthers would be, from a strategic perspective, in the long run, if China really is the threat, but we have all these very effective allies and relationships we have created since the end of World War II, what I would prefer is, in the long run, we isolate and contain China and its allies. If you want to we can complain about allies, but I'd rather have our pain in the ass allies than China's allies, right? Would you rather have our allies, or would you rather be in league with Russia, Iran, and North Korea as your allies, right? So I think from economic strategy perspective, you want to isolate their economies and then lower the barriers between our economy and all of our friends, right? So I think, right, the Trump administration, unfortunately, is pursuing the exact opposite. I think we are raising the trade barriers on our friends who can help us with some of the shortages in our economy. We don't have a lot of rare earth processing capability right now. We actually have a lot of rare earths in the ground in the United States. And we need to reduce our permitting processes in order to build the factories necessary, the refining capacity necessary. But in the meantime, there's Australia and Canada, which have no people but a lot of minerals, right, that they could easily sell to us. Right? That's just one of the benefits we have in the semiconductor area. We may have difficulties in our semiconductor industry, but Taiwan, South Korea, and Japan could be valuable allies in helping us overcome those shortages. So if that's the case, then I think what you'd want to see in terms of the law is use the broad powers under IEEPA, use the broad powers under what is called Super 301 and Section 232 of the Trade Act, which I assume the administration is looking at right now as Plan B for when they lose the tariff case. You can recreate some of what they want to do using narrower application of IEEPA, using Section 301, which aims at unfair trade practices of other countries, and Section 232, which looks at industry or commodity-wide trade imbalances. And rather than use those to put a 40% tariff on Switzerland, what does Switzerland ever do to us, right? I was talking to a Swiss person. It's very funny. He didn't think it was funny. I thought it was hilarious. He said, "What did we do to Trump? Why are we paying 40% and the Italians only paying 20%? Why does he like Italy better than Switzerland?" And I was like, there's lots of reasons to like Italy better than Switzerland, starting with the food. But then they said, what are we supposed to do? What is Switzerland supposed to do? We want to do what you want to get us down from 40. I didn't know what, actually, because there was no country-specific, right, report and measures particular to Switzerland or to Poland or to Italy or to France. So I would say instead, take all these powers, which are still, I think, available, and create a country-by-country tariff regime and aim the tariffs at our rivals and opponents in world politics and reduce them for our allies. And that, to me, would just be the very first step. The whole problem is big, but this is, I think, an obvious first step to take that you would then build on.
And let me just add one more thing. Right now, to me, the problem that's most acute is the critical minerals and then the other raw materials, like industrial diamonds that we need for everything in the entire supply chain is in China. I think we have a huge disconnect between the executive branch and Congress. We really, really need a lot of appropriated money. We'll see what happens with IEEPA, and I actually have a slightly different opinion about how the courts are looking at this and how they might rule. But what the government really needs right now is appropriated money. What I really hope from the 301 tariffs that were in place and the steel and aluminum 232 tariffs that are bringing in a lot of money, Congress can appropriate that to the federal agencies for rebuilding our industrial capacity, because we just can't wait for market forces to kind of figure this out. We need to build quickly. Right now, the U.S. has become the epicenter, thankfully, of critical mineral processing. I did a lot of work in the first Trump administration, including the 2020 EO, to make those investments in the United States happen. Now they need to grow. But what is the government doing? The Congress is not. It has stalled the Defense Production Act to give the Department of War money to fund these critical capabilities. The money is there. It's resting with Treasury, but Congress won't appropriate it. And so what's so frustrating to me is that Congress just feels like it could still monkey around and play politics when we really need the appropriations to do what the executive branch can do, which is kind of planning to do right now, which is Operation Warp Speed on critical minerals and other industrial capabilities.
Marta?
Yeah, so, in my work on policy, there's a couple of themes across the board that I flag. And I do, again, on drug supply chain resilience issues. Number one, there is no free lunch. If we want to have more resilient supply chains, reliable supply chains, we'll have to pay for it. That's where it goes to Congress. The administration can only do so much, right? It's ultimately Congress has the power of the purse. And so they need to step in and adjust for that. Another question that I always ask policymakers is, what problem are you trying to solve? And then following up, I was like, is that really the problem? So if you hear this debate about China and then, onshoring is not, the fact that we don't make drugs in the United States is not really the problem. That's a solution, a potential solution to the problem. And this actually goes back to your question about where could we be getting, drugs and what are the alternatives, and kind of John's point about thinking about allies. So actually, most of the drugs that we buy in pharmacies are made in India. And India has been very nervous about their own, and that's how they are inexpensive. India relies increasingly on inputs from China. But they have gotten very nervous about their own exposure to China. This is a really important business for them. They themselves don't want to be cut off. And also exports to the US are extremely critical. So they have started to invest so they've started to build industrial parks and do subsidies so that their own manufacturers, Indian manufacturers, don't rely on China. This hasn't cost US taxpayers anything. This is really great for us. So now you have a situation, what's interesting is if there is now it's going to be 10%, but there was a 20% tariff on Chinese products, under what I call the fentanyl tariffs. And what that meant that an Indian manufacturer selling a drug into the US using Chinese active ingredients would actually have to pay the tariff because it's considered a Chinese product. That's where the substantial transformation takes place. And so this is actually a really interesting scenario where the tariff was going to get Indian manufacturers to move away from China while we retain a less expensive drug. But if you were to put the tariffs on India, that whole thing goes away. And as a matter of fact, we probably would push Indian manufacturers closer towards China, which would be entirely opposite of what we want. So we need to be really carefully thinking about what is actually a tool and what is a problem and how to map it and really think through the strategy, because you have to really be careful because there can be some major unintended consequences depending on how you play it.
So we're going to take some questions here. The only principle of the question and answer by the audience is that please pose a question. If you want to make a statement, we'll have you on the panel next year. But let's see what questions we have from the audience. And we have microphones. Yes, sir.
Oh, it's not. No.
No, turn it on.
We'll come back to you in a second. We'll start over here. You're next after that. Let's see if this microphone's working.
It is. Hi, Brendan Mansell from Alston and Bird. I've long thought that the construction of the artificial islands in the South China Sea is less predicated on military control of that area and more about capturing exclusive economic zones. And I recognize that the United States is not a signatory to the UN Convention on the Law of the Sea. But my question is, when we're thinking about avenues to challenge China, particularly in the legal context, how much will we be relying on international institutions versus multilateral treaties with allies and other partners versus domestic changes? Is there a hierarchy of preferences here, and what are the most effective legal levels to analyze here?
We have a lot of questions, so go do an answer, and we'll move to go ahead, Ryan.
Sure. I'm happy to just take it at least briefly. I think you're absolutely right. Certainly the islands was motivated at least in part by an extension of EEZs. But when you're actually trying to solve the problem, when you're trying to think about which legal tools to deploy or principles to recognize in an international context, it gets thorny because you really want to rely on U.S. law is the basis of all of your activity while being consistent with principles in an international context that you might not even really, that the country might not recognize, but that you don't want to impinge upon to alienate potential allies and partners. If you'll notice in the South China Sea, for example, the one ruling that the United States keeps referring back to in every statement about PRC destabilizing activity in the South China Sea is the 2016 Arbitral Tribunal ruling of the Second Thomas Shoal. And that is because that is a ruling the United States recognizes. So even if activity is happening around Scarborough, even if it's happening elsewhere in the region, the United States, the State Department, is first going to recognize that particular ruling and point to it as a basis of continuity and to continue referring back to whatever principle was established before.
I want to try to get another question in, so we'll come back to you if you can. John, go ahead.
So thank you. Your fellow for law technology. The Chinese don't want me to ask this question. Yeah. That's what's happening. So there's something that, John, you sort of touched on, and maybe Martha touched on it a little bit too, that I thought would have been a more central focus of this panel. And so I just want to make an observation and ask the panel to react to it. Which, look, why the Chinese have 200 times the shipbuilding base of the United States is not that our export controls are too weak. It's the Jones Act, which protected that industry to death. The reason why the Chinese a monopoly of rare earth minerals is that federal regulation out of the United States. So the great disadvantage that the U.S. is facing China not control is its overregulation. The panel to because part of not sustainable endlessly. And what can really help us win here is innovation.
Okay, sorry for the microphone. So those who want to ask questions, maybe we go use this microphone. John, why don't you go ahead and respond to that?
Oh, I agree in part. So I think the problem has two dimensions. One is export controls, import controls, which are designed to stop China's ability to use its advantages to disrupt our economy. And then, as you say, Mario, to rebuild our domestic capacity. And I agree. I think we shouldn't just overly emphasize subsidies of targeted industries, which is exactly what China's doing, with their strategy is to identify critical industries and subsidize them. And, they have enormous faith in central planning. And you could say that the Soviet Union was not as great a competitor to us as China is, but they also lost the Cold War because central planning doesn't succeed as well as a free market. So I take your point, especially, the areas well, like environmental law, right? We have enormous restrictions on mining in the country and energy production. And these are areas where if we lifted some of these regulations, the economy itself hopefully could rebuild quickly. It just seems to me in some of these areas, like shipbuilding, for example, the short term, it's going to take a while, even if you start deregulating, for industrial capacity to build up. So that's why there are other things you could do, for example, allowing portions of American warships to be built in allied shipyards, which I don't think is allowed right now, but you could start doing, right? The Japanese and Koreans have enormous shipbuilding capacity, greater than ours. I'm from Philadelphia, and I just read the Philadelphia Naval Yard is being taken over by a Korean shipbuilding company, which is going to start making components for U.S. Navy vessels. I think we could do more of that in the short term to get us over this period to the point where deregulation will then should have its natural effect. And I totally agree. I have great faith in the United States and our allies in a world where we reduce trade barriers to overcome China, or just wait it out. Because if you look at the projections, in a few decades, the Chinese population is going to start shrinking. So I don't think this is like the Chinese economy is just on this ever-growing slope. I think that they're going to peak soon, and then they're going to start declining. They're going to have a lot of internal economic and social problems. So we only need to isolate them and contain them for for some period of time till natural market comes back. It will prove to our advantage.
I'll just add that even if we deregulate, China's will collapse global prices and hollow out our industry. So part of the solution is deregulating, but part of it is the Chinese predatory pricing.
Yeah, I wanted to actually give you an example. So statin drugs and SSRIs and a lot of blood pressure medications use a process called fluorination. And even though the drugs, the final dosage form, and maybe even the API is made in India, India stopped doing the fluorination process. We have stopped doing that. Europe doesn't use it. It's a very, very dirty process and very volatile process. The Chinese didn't really care. And so to the extent that they drove Indian manufacturers out of business. So, when you're thinking about sort of loosening environmental laws, like if India thought that this was just too far, right? So there's just something to keep in mind. Two things on this. Number one is, once China has consolidated dumping, not dumping, they have massive economies of scale. They have lower energy costs. They have lower, labor costs. Even if you were to make this in the United States, you're not just, even without dumping, we're going to have a very hard time competing on that front. So back to John's point, this is not really necessarily, sustainable just alone. And also another interesting thing, China has really turned around on a lot of the environmental violations that they've themselves been doing. The Beijing Olympics really turned it around for them. They started grappling so much with the environment is that they started to investing very heavily. And now actually a lot of the industries they're emphasizing actually infrastructure building and rebuilding them as being green. So just a comment on that.
Okay, let's have a question over here.
Professor Yu, I appreciated your thoughts on the merits of the IEPA case. Do you have a prediction as to the result?
How do I think it'll be resolved?
Yes.
So can I charge? Because that's what lawyers in DC get to do. So
It's a bet on polymarket.
I thought before the case that it would be 50-50, just like on the merits, reading the briefs. I thought that the Trump administration had the weaker argument on whether it was a national emergency and a stronger argument on the statute and whether a financial penalty, a tariff, could be considered part of regulation of imports and exports. Having listened to the oral argument, I think the Trump administration is going to lose on the tariffs. I think that Chief Justice Roberts is offering this major questions doctrine, grounding for striking down the tariffs as a kind of meeting ground for all the different groups on the court. I didn't hear from the questions, although the questions obviously don't tell you how they vote. But I didn't hear a lot of, in the questions, strong support for the tariff regime on both grounds. I saw sort of half-hearted, and really a lot of the questions were really directed in a tough way on the government. And I think the government didn't have great answers for some of the questions. I was particularly struck by Justice Gorsuch's line of questioning where he said, and I think this is what's going to help motivate the court, where they said, if we upheld a trade deficit as a national emergency, then don't we have to uphold climate change as a national emergency? And doesn't that then allow under IEPA, under your reading of IEPA, the government's ability to impose a carbon tax on every import and export that comes in and out of the country? And I think he's right that how do you say that climate change is not a national emergency if you say the trade deficit is? So I think because of that, you're going to see the court say this is where it stops. And that gives them the ability to place further limits on the idea that an emergency can just be caused by a slow social or economic problem.
I think if it's decided on foreign policy grounds, then the president might win, but I think it's going to be decided on textual grounds. And I think when you compare, and some of the justices were pointing this out, if you actually look at every trade statute that allows the president to tariff, it expressly says duties, right? And there's a process along with it, and IEPA looks very different. And I think based on textual, the president is likely to lose.
Yes, I'm Roger Pilon with the Cato Institute, speaking for myself.
Of course, God has made the microphone work for Roger, not Mario.
Well, thank you, John. The discussion has raised nothing so much as the question of whether a free society can compete in a high-tech world against a planned police state. And it seems to me that we are competing in the chips area far better than China, which is why they have to steal our technology there. But how long can this continue? And I want to pick up on some of the points John made. The Constitution is not a suicide pact. It seems to me that if we, to follow up on Mario's point, if we had a little smarter, selective legislation, we will be able to compete. But make no mistake about it, you look at the Chinese Constitution, and it's clear right from the start that it is created to enable China to create socialism through the Chinese Communist Party. They are bent on that in so many areas, but it seems to me the answer, and I wonder if any of you would comment on that, of some other ways beyond the Jones Act in which we can have a smarter policy and still remain free.
Go ahead, Rein.
Thanks very much. I think this is the defining question of our time, to be honest with you. I spend a lot of time thinking about this question. I don't have a satisfactory answer. I'm hopeful that some of the smart minds in this room can help devise the appropriate balance. But it seems to me, and something that's made me deeply uncomfortable, is that we can't really deny the progress that China has made in some of its development objectives. That it is succeeding in creating an efficient system for its purposes that may not be capitalism to make a profit, but it is certainly to produce widgets at scale that are cheap, that are cheaper than ours, that are made faster than ours. And not just widgets, but dopamine, if you look at TikTok. Or if you look at any number of its exports, whether they're the willful product of its political economy or as part of a deliberate strategy to export its socioeconomic and political model to other societies. And so this is something that I worry a lot about. But I have faith in the American system. I mean, it sounds almost religious. It sounds almost like a manifesto, but I just genuinely believe, after watching this brutal machine of efficiency attract so many hearts and minds and people in my generation, not just abroad, but even in the United States, to beat China by becoming more like China. I worry about that temptation, but I think that the creative chaos, the opportunities where things really go awry in our system, is what confers this compounding American advantage. It's when our guys say the wrong talking points and end up creating an accidental new principle that we can latch onto that ends up winning battles in future discussions with the Chinese. It's when our innovators discover something completely by accident that is not designed to fulfill the mandate of a 15th five-year plan, but simply because they think it's cool, or because they got the recipe wrong, because their supervisors are not breathing down their necks to the same degree. They don't live in abundant fear. That I believe the American system has something to offer the future, and that I believe we will be able to outcompete the Chinese, not just by out-innovating them, but by architecting new means of living as we do, by believing in the dignity of the individual and the American idea.
So we're a little bit over time. However, the overlords at the Federalist Society have permitted me to let a few other questions come in. So,
excuse me, we are members from the Federalist Society, and we came from Brazil to visit this convention and participate. And my friend Daniel does not speak English, so I will translate his question, okay?
Meu nome é João Daniel.
My name is João Daniel.
Eu trabalho para o governo do estado do Rio de Janeiro, no Brasil.
I work for the state government of Rio de Janeiro, in Brazil.
Essa é a minha terceira vez na convenção da Sociedade Federalista.
That's my third time in the lawyer convention of the Federalist Society.
E estou muito honrado por isso.
And I'm very honored to be here again.
Recentemente, o Brasil,
Brazil,
país rico em terras raras,
a very rich country in rare earths,
assinou grande contrato com a China.
Signed a major 10 years contract with China.
De 10 anos.
Pode continuar.
Nesse acordo,
in this agreement,
esses elementos serão explorados pela China a preço de banana.
This element will be exploited by China at a bargain price.
Como os senhores pensam que os Estados Unidos devem lidar com essa competição internacional sobre as terras raras?
How do you gentlemen think the United States should deal with this international competition of rare earths?
especialmente no caso do Brasil.
Especially in the case of Brazil.
E o que os senhores acreditam que deva ser feito para impedir o avanço do regime chinês no tabuleiro do mercado internacional?
And what do you believe should be done to prevent the advance of the communist China regime over the international market chessboard? And as I will gonna translate for him the answers, I will be in the table, okay? So I already apologize.
Thank you. Okay.
Yeah, I'm happy to take this. I've been doing critical minerals and rare earths for like 20 years. But two things. One, we also have a problem with the Amazon rainforest and China's penetration there. So just like everybody should keep an eye out on that, which worries me. But on what's been really remarkable that's happened, again, outside of China, the U.S. has become the epicenter for critical minerals processing, right? The mines are all around the world, but we're doing the separation, we're doing the oxides, the salts, we're making the metal alloys, and then down to the magnets, right? So every country now has a choice. If a country has valuable resources, you either can work with the United States and actually get a fair market value for the valuable resources you have, and then potentially license some of these technologies we're developing for the country to better utilize its own resources for its own economic benefit, or work with China, where China will exploit the resources and pay you pennies on the dollar. Now, the governments, China pays off the governments, right? And it bribes the government, so governments sort of give this benefit to China. But the more people speak up, I've seen a huge shift in African countries where they're trying to work with the United States with the mineral resources because they know it's going to be a fair trade now that we're growing in this sector. And I think other companies are going to see sort of the alternative model to China now that we're developing and hopefully choose the United States.
I don't see.
I have a question for John, actually.
I was about to say
Because
something.
Brazil comes up, right? Think about IEEPA tariffs and how the President Trump has been using tariffs in that context. I would love for you to comment about how this fits into the picture.
Yeah, I have two thoughts. One is that if the Trump administration loses on IEEPA, I don't see how you're going to be able to use the trade laws to impose sanctions on countries. I believe with Brazil, which we have a trade surplus, right? I mean, Brazil isn't a national security threat because of our trading relationship. You would have to go to Section 232 or Super 301 and identify specific things that Brazil does in trade policy or specific commodity, I think, in response to Marta's question. The broader question I would say is this is very similar, I think, to what China's doing with the Belt and Road Initiative, which is making huge investments in developing countries to try to capture. And this is the radical part of me that I thought about during the COVID-19 epidemic, and I think the growing evidence that China is responsible for the lab virus leaking or not stopping it and not warning the world is I don't think China should benefit from the protections of international law when it's violating it left and right. So when Brazil eventually, I would say, break the agreement, keep all their money, and then let them come try to collect. And I don't see why the United States, which is generally in favor of investor protections, should use international law to defend investments that China is making all over the world. Just like I think nations should have taken stricter measures against China in response to COVID-19 I was like all in favor of canceling their ability to hold treasury bills. Almost exactly the same amount of harm they imposed on the world. Why should they get the benefit of the international law regime that the United States and its allies have built to collect on these kinds of Belt and Road Initiative investments when eventually, as I think the time has come in African countries and some Latin American countries, this debt is designed to be so overwhelming, and then China comes in like a bankruptcy proceeding and then starts seizing port facilities, factories, and industries. You don't have to give them, right, their money back. That's what the communist countries did in all their revolutions in the 50s and 60s when they took over countries, and then they canceled all the debt that they owed to Western countries. But this is an interesting example. It's just like what they're doing in the South China Sea, where they are violating international law and they're pretending they're allowed to create fake islands in order to control the flow of oil that they need to have in those waterways. I would say, why should the United States Navy give the protections of international law to these fake islands?
We'll do one last question, please.
Thank you. So we have the legal framework in the United States to combat the predations of the CCP on American supply chains, but we've had material failures from the executive and the legislative. And so my question for the panel is, do you think that we could look to the states, particularly attorneys general, to start fighting some of these battles in their consumer protection department? Specifically, I think about the world's largest asset managers, many of whom are based in the United States. They don't put in their disclosures that China is a designated foreign adversary. They don't put in their disclosures that a lot of the valuations that we see in these Chinese companies like Alibaba and Tencent, many of us hold these companies and, index funds. They don't tell us that their valuations are likely fraudulent and that we can't actually see how much money they're making because we can't audit them, right? So I would say that there's a strong chance that we could bring consumer protection claims against, at least BlackRock and JP Morgan Chase and some of these companies for including them in index funds and not disclosing. And maybe that mitigates some of their influence to American capital markets. And also, thinking about the fact that we have Chinese military industrial complex companies sending in cameras to the United States. And the majority of Hiltons and Omnis and hotels across the country and a lot of different businesses across the country put their cameras up. The CCP has access to all of that information and they can use it to feed their AI and train their AI, but that's not disclosed on the cameras that we're buying in the United States, right? So do you think that there's a chance for attorneys general to step in and maybe fill the gap where there's been material failures in the executive and legislative branches?
So this runs into the problem, of course, of general federal preemption over most national security and foreign policy affairs. So I think there are some things that attorney generals can do, as you point out, consumer protection, perhaps not letting Chinese interests own land near sensitive federal military installations or critical communication networks and so on. But in general, I worry that having attorney generals starting to play in this field will run into the general field preemption that exists on foreign relations. There are some cases going to headed towards the Supreme Court. They're going to test this principle. I'm thinking in particular of the litigation between Texas and the United States and immigration, right? Which tests what the Supreme Court has said in Arizona versus United States. Immigration, like foreign relations, is preempted and completely federal, and states have no role. But Texas is pushing a case right now to try to get the Supreme Court to re-examine that. But for right now, I'm not sure I want attorney generals sort of taking actions that interfere with federal priorities, regardless of which party's in charge of the administration.
I'll just add, the president can use his IEPA power to prevent investments in companies without the appropriate sort of disclosure, since the SEC and the PCAOB and they refuse to do anything. So the president can also use IEPA to expand CFIUS jurisdiction to areas where it doesn't exist for foreign countries of concern. So IEPA, even though setting the tariff stuff aside, is a really powerful tool to address a lot of these gaps. People just need to remind the administration that they have these tools.
Okay, so we'll end with that. I wanted to make a brief announcement on CLE. Since this is the last CLE panel of the day, please be sure to check out by scanning the QR code that you scanned when you checked in. There's a 5 p.m. lecture. We now turn to a networking break. It always makes me laugh that it's actually on the schedule. It says networking break. We know you've been doing that all week. I want to please thank our panelists and give them a round of applause.